Good morning. This is very cosy. Thanks everyone for coming despite the cold and the hour and the jet lag. I'm very excited about this panel, which has been put together by Barry Lynn, who many of you know is a hub of all things antitrust, and Christian Dacuna at EDPS, where they've been navigating this really fascinating work between privacy and competition. And I'm really pleased to see so many panels this year that are kind of in that intersection, and we want to explore it a bit more in this panel. So I was reflecting on the theme of the conference and the age of intelligent machines, and many of you go to conferences and they're all on these hype themes of the moment. AI, I think, is a really interesting one, and robotics and machine learning, because actually we're in a very limited vision of what those technologies actually can achieve. I think it's when corporate interest, now there's a lot of interest in it, there's a lot of money behind it, but when we talk about intelligent machines, I think we've got quite a limited scope at the moment. And the nice thing about being in a university setting is that you can think across different disciplines and time, and so we've been thinking about intelligent machines in terms of states and corporations, going back to work of Rousseau and Smith and Hayek and Hobbes. And when we sort of can take that broader scope, we can be, I think, much more ambitious about what an intelligent machine, if it's a state, or an intelligent machine, if it's a corporation, should be doing when we are faced with some of the challenges that we have in the contemporary market. So in this panel, I think it would be really great if we can explore, there's a particular set of challenges around data-driven companies and the kinds of monopolies that they are acquiring, and I think a degree of immaturity in how our intelligent machines, such as states, are dealing with it. In the UK, I've been tracking, for example, some of the work around health data and the way it's just being treated as a sort of a good that can be given away without necessarily a trade that recognises its commercial value. And when we're in the fog of no price competition, we need, I think, some more ambitious approaches to competition law. And I think this panel assembles many people who have been thinking very creatively and progressively about how competition law can adapt to deal with data monopolies. So with that, I welcome Barry.
Thank you, Julia, and thank you all for coming out today. That was a pretty good introduction. I'm just going to put things into a somewhat political context. Just a little bit of background. I run the Open Markets program in New America, which is in Washington, and what we do is we look at, as Julia said, competition policy, at antitrust. And we come at this not so much through the privacy angle, but just looking at corporate power. And what we see today in this space is we see some powers unlike any we have seen in our society in a very, very long time. You know, Google, Amazon, Facebook, to a lesser extent, maybe Microsoft and Apple. These companies have a scope and a scale and a reach that is really unprecedented in our society, and they pose economic problems, economic challenges, but also political challenges, social challenges. And as Julia said, we've been a little bit slow in sort of dealing with this, sort of facing up to the magnitude of these challenges. This is a matter about, with these companies like Amazon, they are challenging the way we do commerce. Essentially, they're crushing markets as we know them. They are internalizing markets. They are, in many cases, we don't really have market systems. And that's a challenge for economists to deal with. It's a challenge for people who care about commerce and about the well-being of businesses as we've known them. But what we want to focus on especially today is the effect of these companies on freedom of expression, our ability to talk to each other, the flow of information between person and person. I got into this line of business or this line of inquiry close to 10 years ago, just looking at, in my case, I was a I've written a couple of books, and I was looking at the rise of Amazon and the degree to which Amazon was able to sort of take control over the market for books in the United States and the way they exercise that power. I mean, just to be clear, I'm going to focus on books and I'm going to focus on journalism just because these are businesses in which these are like ways in which people exchange information and ideas with one another. So in the case of books, even 10 years ago, it was becoming evident that you had a single monopolist that was capturing control over this marketplace and had learned how to manipulate the flow of books between the author and the reader. Where we are today, just to be blunt, is we have a company which controls 50, 60, 70, 80, 90, in some cases 100% of the flow of books between the author and reader, depending on what segment of the market you're talking about. And they actively manipulate those flows. And they manipulate those flows by pricing different books to different people in different ways, by showing different books to different people. And they do this for reasons that, for their own purposes. Amazon is also a publisher. They're vertically integrated into publishing. So they manipulate the flow of books for a couple of financial reasons. They do it in order to steer people towards their own product and away from the products of other people. And they also do it so that they can actually extort money from people to ride their railroads, to ride their rails to the market. If you don't pay them what they ask, you don't get to ride their rails, you don't get to the reader. What we're seeing increasingly also in journalism, there's been a lot of discussion recently about the rise of fake news in our society. I'd say that that's actually perhaps somewhat less important than the fact that we have seen this sort of choke pointing of the flow of news across two platforms, Google and Facebook. This is especially true in the United States. And these companies, like Amazon, they actively manipulate those flows. They alter the ways in which information moves between the writer, the journalist, and the reader. They do it for commercial reasons. They do it to make more money. But they increasingly may do it, and these companies are becoming more and more comfortable in their role as censors. So what we want to do here is have a discussion, but before we get into the discussion, we have a great array of people to look at various aspects of this issue. But I just want to make clear that what we are talking about ultimately is the freedom of expression, the freedom to share ideas with one another, the freedom to process information in our society the way we have done for more than 200 years. And so this is on a positive side. I do want to note a couple of things that have been going on. Is that we have been really slow to face up to the magnitude of this problem. But in the United States, there have been a number of breakthroughs recently. Just in the past year, we have seen. I'll give you a short list. Elizabeth Warren, the senator, very powerful senator, she gave one of the most important speeches on antitrust, and she looked at what was going on in Silicon Valley, most important speeches in about 80 years. The Hillary Clinton campaign, they really said this is a major problem, and they sort of promised to address competition policy, the monopoly problem in the United States. We saw this with Renata Hess, the acting Attorney General, Assistant Attorney General of the United States. She came out with a speech back in September in which she said, the neoliberal frame, the Borkian frame, the consumer-centric approach to competition policy, it's over. We're done with that. This frame that has been in place for the last 35 years, we're done with that. So we've seen this really major change in approach, this sort of awakening to the fact that we have a problem and that we need to approach these things entirely differently. And one thing, and now we have, as you all know, we have a new president of the United States, Donald Trump, and we do not know where he's going to take us on these issues. One thing that is increasingly apparent, though, is that he is moving also away from the neoliberal frame, the frame that we have used for the last 35 years. Is he moving towards down a path that we would all welcome? That's not at all clear. But he certainly is moving away from where we've been for these past 35 years. So anyway, I want to start off by turning us over to Casey, and I'll actually just let people sort of introduce themselves. So.
Maybe just the mic. Cool. So my name is Casey Oppenheim, and I don't have much to add to the panel in terms of legal analysis, policy analysis, or general knowledge about the subject of platform monopolies, but I think I'm the only one who has the honor of experiencing firsthand being on the wrong side of a platform monopoly. And I co-found a privacy company called Disconnect, and we're a consumer privacy company. Proud to say that we are powering privacy for over 50 million people every month now, which is awesome. We were kicked out of the Play Store. We had a popular app that was in the Play Store for a very short period of time, and we were kicked out by Google. And the reason they gave was, I don't know, it's been rough. But I think they basically could give any reason. That was the kind of the point that I took away from it, because if you read the terms of service of the developer distribution agreement, they really don't need to give you any reason. They can kick out whoever they want. In our case, they kicked us out because we were interfering with third-party services, ad services, and there was not much that we could do about it. We did file a complaint here in the EU. That complaint is, I guess, still technically pending. But I think that Barry talked about just ideas and expressions being crushed by these platform monopolies, and I think in our case, there's a broader issue, which is apps. The open web has basically gone away. It's all about who owns the biggest platforms, and there's been this huge revolution, the app revolution, where most people are spending most of their time in apps, especially on mobile, and more people are spending more and more time on mobile. And so there's really this choke point for censorship of ideas and expression that are these app stores. And we experience this directly because if you're not in the Play Store, you basically don't exist for, according to Google, I think they have 1.8 billion people using Android now. I'm not sure what the statistics are about the Play Store versus non-Play Store, but I will tell you in the United States and the EU, if you're not in the Play Store, good luck getting distribution of your app to more than a few people. It's very, very difficult. And so that's basically, I think, why I'm up here. I'm not sure how long I should speak initially, but I'm happy to continue. Okay, I'm not done yet. So, what's that?
You've come a long way to say this.
I've come a long way to say this. Okay, so what else do I want to say? I mean, I think that the real issue that we're dealing with is that without regulation, these monopolies basically crush consumer rights. At heart, I'm a consumer rights advocate, and consumer rights has been my passion for my whole career. And I generally feel that consumers get what they want. On the internet, it's happened time and time again. We've seen it with DRM, for example, with music. Consumers actually have, if you think back to the Napster days and how that all played out. I mean, consumers definitely, influenced the way that the music industry evolved. I feel that in this case, they were going up against some very powerful forces back then, the record industry and all the rest. I feel like the difference between that fight and what we're dealing with now is that Google and Facebook and Amazon and a few others, they have so much power. and they've integrated, their search engine with their maps, with their operating system, with every single step of the tech stack, and they're just destroying competitors left and right. And they don't really have to answer to consumers, because for a lot of consumers, Google, Facebook, Amazon, Apple, that is the internet. That is the entire internet experience. And so there's not really a choice about being on their platform. And if you're on their platform, they are controlling the experience from start to finish. The other thing, and this is, other people are going to be able to speak a lot more eloquently than I am about this issue, but it seems to me that within the corporate structure, at least in the United States, corporate directors, chief executive officers, they have a fiduciary duty to maximize shareholder value. So basically, even if Sergey and Larry and Mark Zuckerberg, have all the best intentions, when you go public in the United States, you have this fiduciary duty. And if you don't do everything you can to maximize shareholder value, you can actually be sued for a breach of fiduciary duty. And this presents a lot of problems for consumers, I would argue, because basically you have people who are in control of these companies. And again, regardless, I know a lot of people who work at Google, who've worked at Google, who were there early, who are there still today, who are friends of mine. I don't think that there's this evil intention, but I do believe that there's this, basically that we're set up where they kind of have no choice but to go as far as they possibly can with capitalizing on their monopoly status. And so they continue to go further and further and further until somebody's going to stop them. And then you get into the issue that I've experienced firsthand in the United States with Citizens United, where corporations can give huge sums of money and exercise enormous power in the political system. And so you have a situation where you have politicians who it's not necessarily in their interest to stand up against these giant corporations. And I know in Brussels, Google throws great parties, and they put on this conference, and they wield enormous power. And I think that I'm definitely I'm jaded. I want to have some sort of a positive spin on where this is going, but I will be honest with you, I don't see it right now. I don't see how this is going to get anything except for worse for everyone except for Facebook and Google and a few other companies. In the United States, the third quarter ad revenues came out. Facebook, Google had 99% of new advertising revenue. This is not slowing down. And their platforms are getting bigger and more popular and more essential to everyone's life. It's very difficult, I think, to. I know from personal experience. I use Google products all the time. Facebook less so, but Google, I rely on them for a lot of different things. They are providing access to the world's information. That's their mission, and their algorithm is not organic. Right? It's partly organic, but in their terms and in their policies, they say we have a right to manipulate the results however we want. And they do it for their own benefit because they're trying to make more money. And so you've seen them put out of business many different companies who did rise organically to the top of the results. And I just don't see where this ends. So this is super gloomy. I'm going to give the microphone to somebody else.
Well, thank you, Casey, for getting us off on the right tone. Next, we have Liza Lovdahl Gormsen, who is from the British Competition Institute, and I am going to actually stand up so she can sit in this seat.
I'll stand up. Good morning, everybody. From my teaching days, I kind of like to stand up when I talk. For some reason, I don't know why. So, As Barry has said, I'm Liza Lovdahl Gormsen. I work for the British Institute of International and Comparative Law, which is an independent think tank in London, which has existed since 1894. So we're still going strong. We do a little bit of work with online platforms at the moment, so thank you very much for the invitation here today. So I have been asked to kind of address the question as to whether online platforms or some of them can be considered utilities. And why is that question important? That's important because if they are, then it's an easier way to regulate. We can put them into a regulatory framework. So there are at least two ways you can think about utilities. The first thing is as a natural monopoly, where the service or product is best provided by one provider in the market. And that is usually a physical network. So you would think about the national grid is a good example of that natural monopoly. The other one, which is the one I will be discussing today, the other way of thinking about it is where you have a market with a crucial player. There are other players in the market, but there's one crucial player. And the question is whether that player becomes so important that the market tips into a natural monopoly. And that could be a virtual network with such significant mass and scale that due to network effects that it ends up becoming a natural monopoly. And there is obviously disagreement about whether a virtual network can tip into a natural monopoly and therefore be considered a utility. And the economists would tend to say, and of course I'm just representing the view, I'm not an economist myself, so the economists I speak to, they tend to say that that won't happen. It won't tip into a national monopoly and it cannot be considered a utility. Why? Because they say that the network effects or the scale is driven by demand characteristics in the market rather than supply characteristics. So that's their argument, and of course I know every time you have two economists they would disagree, so I'm sure there's plenty of economists that would hugely disagree with that. Anyway, some would also argue that despite the huge scale and network effects, the platforms, they can coexist in the market. And one example that they're using is the PlayStation's console, you know, the game console. I would argue though that as a lawyer that those network effects can act as a huge barrier to entry. And if you think about Facebook, they have a critical mass of users, and the only way to compete with Facebook on social media is basically to differentiate. So I don't believe this coexistence, that you can have another Facebook doing exactly what Facebook is doing at the moment. So the only way you can do it is differentiate your products, such as what LinkedIn and Twitter has done, in a way that they're also platforms, kind of type of a social platform, but they do it in a slightly different way. So whether a virtual network or online platform can be considered utility really, I think, depends very much on what market we're in. And of course, it becomes relevant in terms of the question of whether we can regulate the market. And you can imagine that there are various views on that, as to whether we should regulate online platforms. And some would argue that that would be a very good thing, to regulate online platforms. And of course, others would say, no, we shouldn't do that because it takes away the incentive, it doesn't foster innovation, and it doesn't create investment. So no. And some would argue that online platforms are two-sided markets, and the network effects is only on one side of the market, therefore it becomes hugely difficult to regulate that. You can't really do it. So let me just move on to what are we doing about this in Europe. So in May 2016, the European Commission, they published a communication on online platforms and the digital single market. And the Commission's view is that there will be no single or unified regulatory framework for online platforms. What the Commission tends to do, though, or one of the things the European Commission tends to do, It intends to regulate potential unfair trading practices against platforms' business users. So that is one of the things they're thinking of doing. And in relation to the online platform regulation, the European Commission is insisting that they will focus on something more concrete rather than intervene with legislation. And what they mean by that is Commissioner Vestager saying we're just sitting here and waiting for the right case to come around. And the minute the right case comes around, we'll jump on it. Frankly, I think that's rubbish. I do. Because there are a lot of right cases out there. I just think they need to get their hand out of the pockets and get on with it. And I do know they are onto some of the cases, but they could do lots and lots more work in this area. So on this rather gloomy note, I will hand back to Barry. At least it's less gloomy than Brexit, which was where I'm coming from.
Thank you, Lisa. That was slightly less gloomy than Casey. The next person we have speaking this morning is Marc Realp Campalans from the Catalan Competition Authority. And any further information that Marc would like to share about himself, I'll let him do it.
Okay, thank you very much, Barry. Well, first of all, thank you everyone. Thank you to the organization. Thank you especially to Christian de Cunha for inviting us to be here, okay, and sharing our point of view with all of you and having this nice discussion, okay. Well, that is everywhere, and the way how companies gather and use this high amount of consumer data has become something that goes beyond consumer privacy rights and affects consumer welfare in general. So we think that all institutions and organizations that devoted to protect and improve consumer welfare are facing new challenges in this data-driven economy. Okay, so we are as the competition authority. There are many challenges, different challenges. A lot of them. We have published a paper recently regarding the data-driven economy and the challenges for competition, where we cover all these challenges, okay, in deep detail. I will not go into all of these considerations, but let me point out just 5 main challenges that we think that are more interrelated with data. Okay, the first challenge for us is how we protect the ownership of data. Okay, we all know that data has value, and one of the reasons is what pointed Liza out is that one of the reasons is because data allows companies to exploit or experience network effects. Okay, so then with the network effects we have the winner takes it all paradox. Okay, where when an operator obtains some competitive advantage in terms of interactions or users, it can achieve a level of quality that, as a result of this competitive advantage, that nobody can replicate. Okay, so therefore, the concentration in this kind of markets is a likely outcome of the market success, and this is something that, as a competition authority, we are worried about. Okay, we think that to counteract this effect of winner takes it all effect, it would be interesting to define and protect the ownership of data. If the consumer could be the owner at all times of the data that he has produced, any operator could potentially offer quality services to those consumers who voluntarily granted access to their own data. In that way, data could no longer be a source of monopoly power. Okay, so for us, the key point is how we grant the access of data to everyone. We could even think of some kind of intermediary platforms between consumers and service providers devoted to manage access of third parties to consumer data. Of course, this service should be provided in a non-discriminatory way to third parties. There are many business proposals in this line. Well, maybe disconnect is some kind of this platforms. For instance, we have also Telefonica, who announced recently that it is working on a platform in this way. So there are many different initiatives in this way on how we protect consumer data, or how we protect the ownership of the data to consumers. Okay. The second challenge that we think that it's important to us is that we need to deal with personal data privacy as a shadow price of services. Okay. There is a video which was published in March this year from the Netherlands Authority of Consumers and Markets, where consumers at the street are offered a free cappuccino in exchange of some personal data stored in their mobile phone. And this is really funny, because the result of the experiment is that no consumer accepts this deal. Okay, no one wants to show their data in the mobile phone in exchange of a cappuccino. Okay, this is really funny, because the real thing is that we as consumers, we use zero price services, and we are paying for these services by means of allowing access to our personal data. Therefore, personal data has become the new money, and companies in data-driven economy determine a shadow price for our privacy. The mandate of the legislator for competition authorities includes not only taking into account price as a variable when looking for competition, but also we have to look at quality. In that sense, we think that data privacy can be looked as a quality variable, or we could say that as a non-monetary price variable. Okay? So the big challenge for us is how to assess and quantify quality as a parameter that might significantly affect consumer welfare. And this is not an easy task. In that sense, it might be worth to jointly explore with data protection agencies whether when there is a degradation in terms of data protection or data privacy, if that degradation in terms of data privacy, if that can also determine an abuse of dominant position. Okay, and this correlation is not so easy. So this is a great challenge for us. The third one is how we capture the great value of data. We all know that data has great value, but some large mergers, we all know these mergers might better be explained by the single acquisition of data than by the turnover increase. Okay. And due to the low correlation between this monetary income and the value of information, current price-centric regulation could lead to improper operation of thresholds when evaluating a merger. However, some low turnover acquisition should not be exempted from merger control of competition authorities. We see, for instance, the difficulties for competition authorities to analyze Facebook, WhatsApp, and LinkedIn, Microsoft and LinkedIn cases. Okay. In consequence, we think that it should be interesting to consider that thresholds should incorporate also the economic price of acquisition as an indicator when evaluating a merger control. Okay, but not only are the competition authorities monetary price centric, so are procurement agencies, and this is something that I want to point out because I think it's interesting. And some procurement agencies, public procurement agencies, sometimes fail to capture the real value of data. Okay, and for example, we've seen many tender public contracts for the transformation of a city into a smart city. Okay, where the price for the contract is $0 because they fail to evaluate the real value of the data that will be managed by the awarded company. Okay. Yeah, the fourth challenge that I want to talk about is how we can capture the great usage of data. Data has not a single use. We all know that. And it's easy to change this use a long time. Therefore, that poses a challenge when defining the relevant market affected, for example, in a merger. Because data can provide competitive advantage even in different sectors than those conducted in where the merger takes place. In that context, competition authorities should look at data protection regulation to learn how it imposes requirements to parties engaged on a specific use of data in order to set restrictions in the merger's clearance. Okay, I think that there might be a coordination in that point. And finally, the last, well, actually I have two more challenges to talk about. The first one is how we enforce competition law in algorithm-based decisions. This is something that we've been discussing here, have been told, that the market is more transparent, so also provides plenty of data that can be processed, and algorithms may take autonomous decisions based on such data. And we all know, for instance, algorithms that can automatically learn that if the price drops, competitors immediately respond to the price, reducing it. So with the effect that in the new equilibrium scenario, all lose out, and therefore the price will not be lowered again. So it's a kind of fixing prices between algorithms. Obviously, in that case, there is no need for operators to explicitly cartelize, because algorithms learn that by themselves. So there is not an explicit agreement between different operators. This makes it difficult to claim a possible breach section of 101 of the Treaty on the Functioning of the European Union, since it would not be a bilateral behavior. Okay? So, in our opinion, it might be appropriate to conduct a review of the competition law, so it captures autonomous practices that can significantly and negatively impact competition. And the last challenge that I want to point out, but I don't have a solution for that, is that we should pay attention to companies that use data to capture consumer surplus. Companies now have more information about users' purchase power, and so companies can use data to capture all consumer surplus. We all know recent studies that show how different users have paid different prices for the same product depending on the brand and model of the device through which they access to the information, and on their browser history and the information stored in cookies, etc., etc. Since competition authorities have among their duties to work for consumer welfare, it is something that we should start paying close attention. And to conclude, as previously explained, the data-driven economy poses many challenges for competition authorities, and at least some of them are really linked to data and privacy. Therefore, initiatives of coordination between authorities such as the Digital Clearinghouse is perceived by the Catalan Competition Authority as a great initiative. We believe that the competition authorities have to face these challenges, but doing it with the help of data protection offices would most certainly help us with such a task. Collaboration will make all of us better, which means better for our citizens. That's it. Thank you.
Thank you, Marc. That was at least less gloomy than the previous two. I'm going to pass it on now to my friend Christian de Cunha, who is from the European Data Protection Supervisor, and I think Christian's going to talk about some of the potential pathways forward.
Thank you, Barry. A lot of my points have already been articulated very eloquently. So I'm just going to try to fill in some of the gaps, and because this is a conference about privacy and data protection, I want to try to persuade you, if you need any persuasion, about why we think at EDPS that this is an issue important issue for anyone who cares about privacy and data protection, whether they're regulators or advocacy or academics. We've been exploring synergies between antitrust and data protection for 3 years now, quite intensely. Our work is on our website. If you'll see the documents and speeches that have come out in the last few years. But it's actually 10 years ago that this debate was really launched, with a case in the US when Google acquired DoubleClick, the FTC cleared that merger, but there was a dissenting statement from one of the commissioners, Pam Jones-Harbour, where she had antitrust concerns, but she also had privacy concerns. She was pointing to the longer-term effects, potential long-term effects, and she referred to something called the database of everything, the scenario where everything gets recorded, and difficult to find who's accountable for that and how you contest it. We could already see 3 years ago that there was an issue with so-called free services potentially escaping regulation, proper regulation. But now, as the debate has moved on and Barry set some of the political context, it seems to us that there's more than privacy which is at stake. There is a confluence of market power, informational power, and now, which is the theme of this whole conference, algorithmic power. And that's why we think it's so important certainly for data protection authorities. I thought you might find it interesting to hear some statistics. The OECD have done a lot of work on concentration in digital markets in the ICT sector. It has accelerated remarkably in the last 10 years, and especially last year in October 2016. Apparently there was a record number of mergers, not just in ICT but generally, almost $500 billion or euro worth of mergers and acquisitions. There's also concentration in the area of artificial intelligence. Startups are being acquired at a rapid rate, and there is already people are starting to register concern about early dominance in the market for machine learning. And yet we often hear the argument that these markets are dynamic, that companies rise and fall really quickly, and it's very important not to stifle innovation by intervening. But there is the so-called MySpace argument, which is that MySpace was there, very popular, and then it disappeared. But the reality is that in the last 10 years, the dominant companies that we see today are basically the same ones that were there, almost a decade ago. So that's not quite so dynamic. They also compare, competition. Experts who I talk to quite a lot, they often compare this with other industries. They say, like cars, electrical goods, a similar process happened in the early days and there was a consolidation and things stabilised. But from a fundamental rights perspective, we think that digital is different. Cars is actually a good analogy for us, because the standards that were set for cars 120 years ago, those had unintended consequences for pollution, for road safety, for the environment, and we're at a pivotal moment in the emerging digital space too, where norms which emerge now and which are accepted could have worrying consequences down the line. So, for example, the norm which prevails now for web-based services is tracking, third-party or third-party tracking. It's keeping you inside a walled garden at all costs. They want you to stay within their space. And that has consequences for fundamental rights to privacy and freedom of expression, as my colleagues have said. And we also have learned in the last year or so that a growing number of people are consuming their news via dominant social media providers. The content that you receive is determined by algorithms. So to give you a personal example, the algorithm on the social media provider that I use knows that I'm a liberal, pacifist Europhile who supports Arsenal Football Club. And that's why all I see on my feed is angry rants against Brexit and Arsene Wenger. So that tends to make me quite an angry man, and it's just bad for my family life. There's also some very interesting scholarship which went to PrivacyCon in Washington DC this month, where they showed through economic modelling that in the advertising environment, platform intermediaries gain disproportionately at the expense of individual consumers and firms who want to advertise. So there is that concentration towards the platforms, according to that study at least. And then we have the prospect of artificial intelligence. Marc mentioned it. People are starting to talk about the idea that machines could collude on pricing, and that could squeeze consumer value more to a much greater degree. Just a word or two about why we think. I mean, this is a privacy conference, but what we're trying to do is explain that antitrust is a very powerful tool for the EU in particular, also for the US, but it has a very limited range of applications, which people often think that antitrust will fix everything, and it won't. But what it can do, if it's deployed effectively, it can be extremely powerful. So it can break up cartels, it can control mergers, and if you're a dominant company, it can determine. It can change behaviour if it's judged that company is excluding competitors, or if it's harming consumers, exploiting consumers. But not all of these tools are fully utilised, and this is really my concluding comment, that we think that privacy experts and data protection authorities and their fellow travellers in the consumer enforcement world can do a lot to assist antitrust authorities in understanding or in analysing the longer term effect on consumer welfare, on data subjects, individuals, of behaviour in the market, whether it's by dominant companies, which comes under Article 102 of the treaty, Lisbon Treaty, or in merger control, where again there is potentially a lot of power in the hands of the European Commission to stop a merger or to put conditions on a merger. On that note, we're trying to bring regulators together. Later on today, there is a panel on the digital clearinghouse, which has been mentioned already. That's us trying to bring authorities, agencies from data protection, consumer, and antitrust together to talk to each other and learn from each other. We're very pleased that Marc is on board, and we hope that as they start learning together, that there can be a more coherent response to some of the behaviour that's taking place in the market, which is bad for consumer choice and also bad for fundamental rights.
Thanks, Christian. I'm going to ask Liza to come and sort of sit up here, and I'm going to stand at the podium just so that we can all be up here during the Q&A and discussion period. And
am I supposed to answer any?
Perhaps. So I guess what I want to do is talk about what we can do about this. And I'm going to talk, I really want to focus on two areas. And the first is actually sort of the language and conceptual frameworks that we use to understand these problems. And then I'm going to bring it back to some more practical potential pathways forward. And just sort of put the discussion about language into some context. I'm speaking as an American. In the United States, antitrust, as we know it, really kind of emerged out of U.S. law and U.S. experience. And to actually put it into real context, the United States was, in some extent, born out of a rebellion against monopoly. Some of you have heard about the Boston Tea Party. That was a rebellion against the British East India Company. That took place in 1773, 3 years before official independence. That was a fight for independence from a trading company. So the United States was, from the very beginning, this was a battle for commercial rights, for individual liberties. People like John Hancock, like Sam Adams, when they talked about the threats posed by the British East India Company, they said it was a threat to their fundamental liberties. That's why they had the British Tea Party. That's actually, the Boston Tea Party, but that's also why they went forward with independence. So, and sort of as in the United States, from that moment forward, for 200 years, anti-monopoly was used to protect liberty. Anti-monopoly was used to protect our democratic institutions. Anti-monopoly, we use it to protect our communities. We use it to protect our families. We use it to protect our ability to innovate. And all of the body of work of anti-monopoly law that we developed over 200 years was designed to protect, it was around the concept of the citizen, a citizen that was interested in independence, a citizen that was interested in having democracy, a citizen that had an interest in participating fully within the commercial sector, to have industrial liberty, as people used to say. And then 35 years ago, we came up with a new frame, and that was consumer welfare. And we've used, for the last 35 years, this frame, consumer welfare, to frame every single thing that we do in competition policy. And now I would argue, and I do argue, that that was a fantastic mistake, and that actually has set us on a pathway towards autocracy, the concentration of power unto autocracy in our society. So that was a switch of one. That was a manipulation of language that set us on a different path in society. So the first thing I want to talk about with our panelists here is: do we need to actually really fundamentally rethink how we talk about these issues? Here we are at a panel, at a conference that approaches this as a matter of privacy and data protection. Is that the right frame? The consumer welfare frame. Here in Europe, should the Europeans be moving immediately today to throw out the whole concept of consumer welfare and move towards citizen welfare? So maybe I'll start with Lisa.
Well, I do believe, and I'm sorry if there's any economist here in the room, I don't want you to take my comment personally. I just think that the economists, they took over the scene of competition law, and they moved into the area of competition law and policy, and they have done so very successfully. So, and I would say I've been persuaded myself. When I'm teaching competition law, I also start from an economic perspective by saying, okay, I always try to challenge and say, is the optimal objective economic efficiency and consumer welfare, and how do we define that? But I do think that we need to take a step back and actually consider whether that framework will produce not consumer welfare, but whether it will produce citizen welfare. So I think it's time that the pendulum swings to the other side, that we at least address these questions and ask ourselves whether the framework, and that's particularly the framework in the UK where I'm operating, that economic efficiency is the main and the only goal. I've tried to challenge that for a number of years, because I don't think that any area of law, in particularly competition law, can have one single objective. That just makes no sense to me. So obviously any area of law needs to have more than one objective, and I just think it's too narrow to think about competition law in terms of economic efficiency and consumer welfare.
I'd like to ask either Marc or Christian to talk for a second about how could people in this room actually help the competition authorities, who are still very much subject to this consumer welfare frame, break out of that and realize that real fundamental rights, the right to privacy, the right to freedom of expression, the right to commercial freedom, are immediately and endangered today in our societies?
Yeah, my opinion is that maybe the problem is not on the consumer welfare, which I think that is something that we have to protect. The problem is that if consumer welfare means only price. So I think that traditionally competition authorities have been looking only at the price variable, this is not the only variable for consumer welfare. I think that we should start looking at other variables rather than the price, the monetary variable. And if we if we do the work in that way, I think that we can manage all these problems. The problem is that, and that is behind, or that is underneath of the competition law. I mean, the competition law doesn't talk only about money, but if we look at in the broader scope, we can defend consumer welfare in other terms rather than the price. And consumer privacy is a quality variable that we have to look at. That's for sure. Having said that, we don't have a proper methodology for doing that, because our history is more, the methodologies that we have are more oriented to the price, which is something quantitative and can be really tackled, but we don't have methodologies methodologies or proven methodologies to tackle for quality variables. This is my idea.
But actually, just pushing you a little bit further, Marc. I mean, issues of people's privacy, their right to privacy, people's right to commercial freedom. Like Casey, he has traditionally for a couple hundred years in my nation, it was felt that Casey would have a right to bring his product to market. And today he really does not have that right to bring his product to market.
Yeah, sure. Actually,
I've been pushing it further. If Casey wants to speak with somebody in the audience, that was regarded as a fundamental right. Now you have to go through intermediaries to do that, and those intermediaries may shut you down. That was regarded as a traditional right. So just pushing a little further, the competition policy authorities really need to open up much more widely than you were sort of suggesting.
I think that I'm saying that we have to open. I'm saying that we have to open our minds. I think that for instance, we should evaluate if, for instance, when a company has a dominant market power, if they degrade in somehow their policy rights, we should see if that can be an abuse of dominant position. We should analyze that, of course. I think that the Catalan is already evaluating a case. I think it's Facebook case, or the Facebook WhatsApp case in that terms. So competition authorities are starting to look at this issue. Yeah.
We have a question, but before we go to the question, I want to just have Christian sort of address the basic issue of, how can actually people in this audience who are really focused on privacy and data protection help break open this kind of very closed way of looking at competition that has sort of taken hold within the competition authorities.
I'm sorry to interfere with your freedom of expression. In answer to your question, the competition world is fascinating. It's extremely, it's big. There's a lot of money involved. There's a lot of litigation, and the thousands of lawyers, extremely clever lawyers, quite a lot of case law, which seems to be. It's often, it almost seems like a pendulum sometimes, trying to understand, what the direction that the court is going in, and you've got the commission giving guidance, etc. But what I would say is that the current commissioner, Vestia, is very open to these discussions, and she is we work with her quite closely, and she's done speeches. She's an ally on this, a potential ally, She did a good speech on exploitation of the consumer recently, which was for DG competition, it's quite a step forward, because they tend to have quite a classical approach to a lot of these issues, very much emphasising price. But the problem, I think, in terms of advice to us, to privacy community, it's to avoid telling competition authorities that they need to start enforcing privacy law, because first of all they can't, and secondly it's that they're not able to do that, and secondly it's not necessary for them to start to apply other areas of law. They just need to be helped to understand how existing principles of competition law, like consumer exploitation, like quality as a parameter of competition, like what it means, what price means in free web-based services. They just need to be helped along the line to understand what the impact is going to be in order to deploy the existing tools in that way. But there's one sort of postscript to this, which is that there is a dialogue constantly between law firms and litigators and the Commission, competition enforcers and the courts, and there is a journey that they're on as well, and so you need to try and be respectful of that. But the most important thing is, don't say that competition law is there to enforce privacy law. It's not, but it does have a public interest objective, which is you need to work within that parameter.
Okay.
Yeah.
Looking forward, Casey, did you offer your case to the US or the European anti-competitive authorities? Second, Christian, what search engine do you use as a standard in the EU Commission? What search engine? And third, is Telefonica the best example of a personal data store? I should trust my data to get control.
I was expecting that question.
No, we did not bring it before the US. I was told it was a waste of money and time, and we did bring it in front of the EU. Yes. Yeah, we submitted a formal EU complaint.
The search engine, there's the browser which is installed on my computer. We use the Parliament IT infrastructure, which isn't the Commission. They have different deals. So we've got Internet Explorer, and then the search engine is up to you to choose.
And what are you using?
What do I personally use? Well, Firefox, Google, yeah.
Use Google. It's just interesting because
Well, it's just, I mean, it's not because it's EDPS policy. It's just, yeah.
Yeah, I have to say that as a competition authority, we shouldn't have any preliminary concepts of any company. Okay, so is it true that Telefonica experiences monopoly power or high market share in Spain in the telecom market? I don't know if that's the case in the personal data market. Okay, if that was the case, we should. I would say that the answer would be no, because be careful, because they can make an abuse of dominant power. But in that concrete case, I think that's a good example to see how big companies are trying to move companies that were out of game previously, or Telefonica feels that he's out of game because the game is played in the field of Google, Facebook, and whatever. So they're trying to get into the field. So I think that they're changing the playing level field. Okay, so that's for me interesting. The initiative, not if it's Telefonica or another one. I say Disconnect is doing the same in another way, but maybe it's the idea. At the end, the idea is the same. So the idea is how we can separate. How can we empower consumers with the usage of their own data?
Actually, just adding to that answer, in the United States, I think what we're seeing, and perhaps what we'll likely actually continue to see under President Trump, is the movement of companies like AT&T and Verizon into this platform space. That's certainly what they're intending to do. And I think to the extent that we're seeing any kind of pattern out of the Trump administration, it's that rather than necessarily taking on existing entities, they may just seek to try and push other cable companies and wireless companies into that space just to create perhaps more competition. We'll see if that works. And we had a couple more questions, so right here.
So one of the interesting intersections of competition and privacy and data protection is this idea of the stifling of innovation, because one of the more economically driven arguments in the United States and other places is that ratcheting up privacy legislation or other types of regulatory instruments ultimately can create economic disincentives against innovation for the companies. Without economic training, this argument seems intuitively like an empty orthodox for me. And I wanted to know, is there merit to the idea that innovation is stifled by the ratcheting up of privacy and data protection law? And if not, what is the strong counter-argument to that?
Casey, you want to?
I mean, does it stifle innovation to have emission regulations? I mean, potentially, but it doesn't mean that you shouldn't have it, right? I mean, it's going to stop you from creating cars that create as much carbon emissions as possible. Maybe you consider that innovation. I don't know. Maybe there's a positive connotation to innovation. But, I mean, yes, I mean, it sets a framework for how you can innovate and what you can do under the law. And I would argue that it's no different in privacy than it is in absolutely any other sector of life or business. That there's regulations on a lot of different things that it hasn't stopped people from innovating. I mean, in terms of drones, I mean, there's regulations saying that you can't put a 500-pound drone in the air that you don't know how to control and drive it down a public, street or whatever. So, I guess that's my take. Maybe I missed it though.
There was a question in the back.
Thank you very much. It's very encouraging that you guys are doing so much work on this, and it's heartening up. The question really, I mean, stories like Casey's make us angry and worried, but the thing that's sort of scarier is, as you point out, the degree to which the stuff that's happening that we can't see, and the degree to which as it were, holding the database of everything gives you a bit of an upper hand. And I suppose the question is, in terms of the regulatory tools at your disposal, the problem about putting conditions or requirements is that if you've got the database of everything, it's pretty easy to see ways around those roadblocks. So I guess the question is, to what extent do you feel, I end up wondering whether to really regulate this space, you need to have, as a regulator, the same level of data access and the same degree of competence and understanding of data as the organisation that you are regulating. Would you agree with that, and do you think you would ever be able to get to that point?
It's a great point. Yes, I mean the answer is that the authorities need to scale up their technical knowledge, their technical the extent to which they understand the technology, and that's a big challenge for data protection authorities now. And it's a question of resourcing and public finances, etc. But also there is in the competition sphere, there is already an expectation of transparency, and if they lie to the regulator, they can be in big trouble. And the data protection regulation, the new data protection regulation, also establishes more clearly the principle of transparency. So there's an interaction between those two.
I'd like to add something to that. Because it's a really important question, and if you actually follow the logic of that, then we would have to make the NSA the competition policy regulator. 100 years ago in the United States, the companies, by today's standards, were relatively small. Standard Oil's was not nearly as large and wide-ranging as say, Google or Amazon. But sort of competition policy leaders, people like President Wilson, people like Justice Brandeis, they said there was two options. There was one is to make government big enough to regulate these really large things, or you make the things small enough so that the government really didn't have to get much bigger. And they chose the latter. We're going to make these things smaller so that we don't have to make government bigger. And in cases where you couldn't make it smaller because it was a network monopoly, like say AT&T back at that time, you neutralized it. You used essentially common carriage rules to neutralize the power in that monopoly. So that was the approach 100 years ago, and I think that approach was extremely successful over the course of the 20th century. Anyway, we had another question.
I would like to add a comment to this question also, and I completely agree that sometimes the authorities don't have the complete knowledge of what companies want to do. Okay, and for instance, we don't really know why Microsoft is paying so high amount of money for acquiring LinkedIn, for instance. Okay, so. In our report, we pointed the possibility that in some cases we could impose to the companies in a merger to impose what we call the inversion of the burden of proof. So it means to ask them what they want to do with this operation, because conceptually, in terms of competition, a concentration in the market is a loss in competition. Okay, so maybe we could ask the companies to define what they want to do with this data, and then we can impose some conditions regarding what they are saying. But we could ask them to tell us what they want to do. That would be a good solution.
Yeah. Hi. I also have a quick comment to your question, which I thought was excellent. Your point is all about information asymmetry. Obviously, the companies sit with all the information, all the data, all the money, all the power. And when I used to work for what was then called the Office of Fair Trading in London, I mean, we were running around in circles. I mean, it was impossible because every morning you come in, all the competition litigators, they'd been sitting working overnight, and we would have submissions of 400 pages. And by lunchtime, we would have a submission of another 400 pages. And that was obviously a strategy to bury us in work. So it all comes down to money. And that was what Christian, he talked about. There's limited resources, limited, we're limited in every way. But what would be good, though, is if the agencies could get more money, that they could be able to afford to employ these geeks, as I call them. I mean, the people that really know their stuff. I mean, we're talking about the 25-year-old who's smoking pot all the time. You know, that's fine for me. I wouldn't mind that. Sit them down and let's hear what they have to say, because I think they're immensely intelligent, these people, and they know everything, right? But it's all a matter of money, I'm afraid to say, and I don't think that the government is ever willing to give the money it takes. It really has to be, because we're competing with the big techs that can buy all of these youngsters. I mean, why would they go and work for the regulator when they can get 4 times the pay? I'm afraid to say that I don't have a solution unless I win the lottery.
And Julie, I think, wanted to make a comment or ask a question.
Yeah, or lead us to a wrap. It's far too gloomy for us to move to coffee at this point. But I do think those opening, those 3 opening haunting challenges of crushing power like we've never seen before, Casey saying he doesn't think it can get better, and Liza commenting that we're not taking enough of the right cases. I think sort of drawing those through what we've spoken about, I felt like there were still some promising ideas. I think one kind of interesting observation is, I'm not sure it's an accident that those prominent speeches you mentioned, Barry, and then the dissent and the double-click case were all by women. I actually noted that every notable remark we had there about public figures and Vestager and so on. So that's quite an interesting development in the last 10 years, and hopefully that will continue. And I actually think there's something quite strong, Barry, in what you said about the rhetoric and linguistics. And it was it's a tremendous part of the Catalan report that they delve into the issue of ownership of data. To my mind, until we tackle that problem properly, we can't have effective neutralisation or control of the scale. And I think that the way that ordinary people talk about data, and that cappuccino example is very compelling, is in the same way that we talk about our bodies and that we talk about our ideas and ownership and so on. So I think that there's a lot that could be done on ownership, and that's one sort of positive that I'd put to the gloomy challenge of the crushing power. A second one is that when we've had, I liked the example of looking at cars and roads, I think that there's a lot of roles that we could have, like sort of inspectors that we had when we had mining and so on. And that could be a really compelling opportunity for young people coming through. I think there's some great techies that are being picked up by the FTC. There's a lot in the UK that the ICO has just announced that it's going to try to make sort of grants available to people who want to do investigative work on big tech and so on. So that's a second positive. And then the third one is I actually just think that the kind of technology innovations that are happening today require far less significant resources than other major advances from the Industrial Revolution, and that we could have a lot more significant public investment in public service research in terms of use of data. And that is something that could start in local areas, and I think has a lot of promise for peer-to-peer versions of a lot of the services that are currently platform monopolies.
So are we out of time? Or
We kind of are.
okay. Can we continue, or I don't know who's running this room. Okay. Well, let's. Until someone kicks us out of here, we can keep going. So go ahead.
I think there were 3 more questions.
Yeah.
So we feel there is a need, there is a demand from the customer to have a kind of trusted intermediary, or trusted party to bring the online platforms and the customers. And this is what we are working now. So in a way, our customers already pay directly for our services, so we don't have any incentive to sell their data, because the only thing that can have as an effect is that they don't trust us anymore, so that they just leave us as service providers. So, and then finally, just to mention that we are working also on a data manifesto that will be published in the coming weeks. So we did that a couple of years ago, a data manifesto, and now we are working with this data manifesto that I think are very interesting issues that I know that we will present this platform.
Okay.
Thank you.
And we maybe had one last question, or?
Yeah. I think there were two.
Okay, two.
Sorry, it's a bit of a big question. So I suppose for the competition lawyers, the way in which we characterise or define power at the moment is based on kind of a very economic test, demand-side substitutability. And I think that in many ways blocks findings of power in the competition context, but also for purposes of economic regulation of utilities. And so we see that markets that maybe as consumers we don't experience, or citizens we don't experience as competitive, we're told are competitive because of multi-homing, or because they're simply not competitors in the first place, a la Facebook, WhatsApp. So I'm just wondering, is there any kind of movement within competition law to change the way in which we define market power? And then, I guess from a broader perspective, if there's no movement within competition law to do that, do we need to have another legal definition of power that might capture the type of dynamics that are at stake that, Casey has highlighted, have non-economic implications?
All right, Ola, thank you very much for your question. I will take that as a competition lawyer. I would say ever since the definition of market power in Europe, which was very much based on market shares and what they call other factors, ever since that definition came into place in United Brands, it has been criticized. Everybody knows that it's a very, very limited test for market power. And I think there is a movement towards focusing on outcome. But I think that's even worse, to be honest. So yes, we do have a problem with the way we define significant market power and dominance in Europe. But until somebody else comes up with a better definition, and the definition is really that a company can act independently of its competitors, its customers, and its consumers. And I don't even think that a company like Google can do that. So Well, okay, that's debatable. But in any way, it's a very, very poor definition. I would agree with you. And I also think there was one very last question in the back.
Actually, we did get the hook just came in, so I think we'll have to take the questions out. So, but anyway, thank you all for coming.
It's very cool. Yeah. Yeah.